Well, so what do you do about the government's argument that you're the one who is undermining First Amendment values, because the whole point of the trademark, of course, is to prevent other people from doing the same thing. So if you win, the slogan Trump too small or whatever, other people can't use it, right?
Other people can't use it as a source identifier of their own, which I think is perfectly
They can't use it the way you want to use it, and you say the way you want to use it is to engage in expression. And then in trademark, there are things that are kind of close to it that are also prohibited, right? So we'll have all sorts of litigation. Presumably there'll be a race for people to trademark, Trump to this, Trump to that, whatever. And then particularly in an area of political expression, that really cuts off a lot of expression other people might regard as important infringement on their First Amendment rights.
Yeah, so a couple of points on that, Mr. Chief Justice. I take the concern, and I think it's a fair one. I think a lot of that concern is dealt with by the requirement that a mark actually function as a mark. That means it's got to bring to mind, in the mind of the consuming public, that it functions as a source identifier. You're not just expressing a common message. It's why God bless the United States or I heart DC. Those kinds of marks don't generally get registered. And I think that if in the main, many political slogans do not get registered for that very reason, and I think it addresses a lot of those concerns. So what we have to imagine is a mark that functions as a mark, and so it's kind of distinct enough and unique enough to kind of serve that purpose and satisfies all the
sorry to interrupt, but if yours meets those requirements, it's hard to see what the limitation would be on all sorts of other things, except to the fact that they think it's, whatever they think is a parody or a joke. And you can certainly find most adjectives and attach them to your phrase. And, all those would be protected, and only a limited number of people would be able to make the, particular comical expression but carrying First Amendment weight that you want to arrogate to yourself here.
I think to some degree, Mr. Chief Justice, that is just built into the regime. And so I understood my friend in his responses to your question, Justice Barrett, to effectively concede that the reason why, if the PTO were to register this mark, the former president sought registration of it, the reason why that wouldn't give rise to First Amendment concerns is because of what this court said in Jack Daniels, which is that the First Amendment and trademark law, when it sticks to its historical function, they play well together. Now, that I understand the concern about there being some chilling effect that might exist because, someone doesn't want to pick a mark if they're concerned about being subjected to infringement litigation. And to some degree, that risk exists even without registration, but I understand that, when a mark is registered, it gives the mark holder added benefits. I think if that is a concern that Congress wanted to identify, which we're a world from that here with this provision, which it was clear from the record that Congress was trying to make it so that no one used these marks, not that so anyone could use it as a source identifier. But if Congress did identify that as a problem, I think it could try to achieve that narrow purpose and through a more narrowly drawn statute. But that's just not the statute that we have here.
And I'm sorry, more narrowly drawn, like what?
Well, I think if the concern is ensuring that political speech or political speech that might not really scream source identifier anyway, that we don't want to register those kinds of marks because there could be some chilling effect. That could be a justification once you're in heightened scrutiny for a particular prohibition, and maybe it would survive, maybe it wouldn't. I'd have to see the justification. I think that's the beauty of intermediate scrutiny. You don't just assume an exception is constitutional. You see what the government says, and then you see if it stands up.